Let's talk for a few minutes about the problem of privilege and how it is to deal with the issues of attorney-client privilege when you're dealing with electronic discovery and the preservation and production of electronic discovery. Remember, we preserved everything. Remember, that's the first step. And so the question is, how do you deal with the production to make sure that you don't inadvertently waive privilege or produce privilege information? Let me just go over what Rule 26.5 says. If a party produced privileged material, it can notify the other party, which in turn is obligated not to use or disclose it, and then must either return or destroy it, take the issue to the court. This rule then only preserves the issue, but it does provide for the potential that you can claw back to your client if, in fact, you show you took reasonable steps in the preservation of the privilege and the protection of the privilege, and that the disclosure was inadvertent. The disclosure may amount to a waiver. That depends on whether it was inadvertent. Now, what's privilege? Well, remember that the Federal Rules of Evidence 502 tell us that inadvertent disclosure will not operate as a waiver if the holder of the privilege or work product protection first took reasonable precautions to prevent it and took prompt measures to rectify. Court orders containing clawback agreements will be binding on other parties and proceedings. So, let's look at this. What are the reasons for the new rules here with regard to the ability for you to be able to claw back privileged information? What is privileged material? What are the meet and confer requirements in order to be able to make this go? What is inadvertent disclosure? So, quick thing about the reasons for the rules here. First, as you know now, the enormous amount of data and the volumes of information that can be produced in this process of preserving and then producing data is one of the major reasons for the new rules. The short discovery deadlines, the theory is, you know, that all this electronic data will just allow you to go ahead and dump it to the other side and do it quickly. Obviously, the short discovery deadlines then, especially in the rocket docket jurisdictions, can really create a tremendous amount of pressure here. Number three, the number of cases is increasing. You've got 325,000 cases in the federal courts that have been filed, and so the numbers of these cases increasing means that individual law firms have more to manage in the way that the cases are going to be handled. Privilege review must be done electronically with special tools in order to be able to sort and process all the possible emails that may have attorneys' names on them, and that process is time consuming. The risk of error is substantially increased. So, what is privileged information? Well, let me suggest to you that one way to think about privilege is to say it just hasn't changed at all. That the thinking of what is privileged is that it is information that's been communicated from a client to a lawyer for the purposes of seeking legal advice and counsel. Now, obviously what this also includes is trial preparation work product is also going to be protected and is privileged, but the definitions of these two terms have not changed. It includes work product that is trial preparation material. Now, what are the meet and confer obligations then that are in place when you're dealing with privilege issues? Well, what you are obligated to do is, if you have in fact discussed ahead of time with the other side about what is going to be the nature of your exchange, you can ensure in those initial conversations that you tell the other side that you intend to maintain privilege for all attorney-client communications. And so you discuss the matters ahead of time, and as part of your protective order in the production process, you can each agree that, in fact, inadvertent disclosures of privilege will not be subject to production and that clawback is possible. Form 35, provisions of a proposed order on claims of privilege asserted in production, then help you frame that language. Rule 16b5 and 6, the scheduling orders may include provisions for asserting privilege after production. and you may cover then these issues ahead of time. What is inadvertent disclosure? So let's think about that. What is it going to mean that I've inadvertently disclosed to you? Well, I have to show that I've taken reasonable precautions to prevent the disclosure from having taken place. And I need to take prompt measures afterward to rectify it once I've found out that it's happened. The reasonable precautions then are the following. The client has preserved everything required. Remember? Everything required has been preserved. The basic ground rules have been negotiated and ordered. Production has been organized according to the key players. Potentially responsive and responsive records have been located. Relevant records have been located. So that what we've done is we first show that we have taken reasonable steps to provide you with all the information. And it's in that process of providing you what we've been tasked to do that this inadvertent disclosure has taken place. The technically adequate copies have been made. In fact, the file server for relevant records has been provided. I've done all of that as my reasonable steps for the production. So, I made the production set. I've migrated the data to a litigation support system. I've searched electronically for the privileged materials. In searching, here are the things that I did. I searched for names and addresses of all known lawyers. I have used lawyer as a part of my search term. I've included the following: legal plus administrative, advice, analysis, attitude, approach, belief, caution, caveat, concern, conference, consultation, counsel, discussion, estimation, examination, gathering, get together, group, guidance, idea, information, inspection, judgment, leadership, limitation, management, meeting, observation, opinion, organization, outlook, position, proposal, principle, position, recommendation, requirement, scrutiny, submission, suggestion, supervision, support, view, warning. These are all the things that I searched for. And this is what we tried to do to make sure we were preserving. That kind of then demonstration that we tried the best we can to preserve. And you obviously will be showing what your search has included and what you were using as your substitutes for lawyering and lawyer advice, can demonstrate that this somehow got through despite your reasonable precautions to preserve. You segregated the potentially privileged material, you bulk tagged it, you electronically stamped it, you automated your privilege log to ensure that this was signaled to you, that all of those steps were taken to show that in fact you were reasonable. And then, frankly, you extracted the materials and you delivered the production set, and it was in that process that the inadvertent disclosure happened. Now, why a separate server is part of a recommendation here to show that you're taking reasonable precautions? Remember that what you have is you have these different servers, presumably, that can be used to segregate your information into the potentially responsive, the relevant, the production, and the privilege. And by having this separate server process, you show and demonstrate your intent on preserving privilege. It provides you with security. It minimizes the chances of mistakes or damage. You maximize the support for your explanations as to what it is that you've done. And the servers are no longer as expensive items as what they once were, and something then that is a reasonable cost that should be borne by you. So, how about prompt measures to rectify? The date when the producing party learned of the production of the material, the extent to which the other party has made use of the privileged material, the difficulty of discerning during an electronic search that information was privileged, and the magnitude of the production, all of these will be factors that the court will consider. So, in dealing with privilege, there is the potential for clawback, but our suggestion is that your best practices should provide you first, in order to be able to meet the burden, if the court is looking at this, that you've shown diligence in trying to take reasonable steps to protect the privilege from being violated or disclosed, the privileged information being disclosed in the first place. Thank you.